Welcome back to Sunrise Daily, and let's quickly try and see if we can establish that connection again. Professor Richard Wokocha, Associate Professor of Public Law, Rivers State University, joins us from via Skype from Port Harcourt, the Rivers State capital. I want to thank you so much indeed. Can you hear me now?
Yeah, I hear you clearly. I hope you can hear me.
Brilliant. That's much better. We can also hear you now. But, you know, just before the tribunals and all the cases will be heard in the tribunals, as a submission from our guests in Abuja saying that as many as 32 in Bauchi State and some other states as well having these tribunal cases. There were cases that were already pending in court that has to do with River State and at the Supreme Court, if I might add. Which was instituted by the APC candidate, if you will, because we had the situation whereby two parallel candidates emerged from the primaries in River State. But Magnus Abe went to court and still believes that he is to be declared, the court should declare him the authentic candidate for these governorship elections that is over now. But what's your impression of what he's asking the courts to do?
Well, I think it's important to notice that Senator Magnus Abe did not just go to court after the election had come and gone. That matter was pending before the election was conducted. And cases don't just die, they have to end. And so whatever value the judgment will be now will be national because the election has been held and has come and gone. But I think it would be good to have on record what was the proper conduct of the two competing conducts. Already the court has declared one to be improper, but it is for the courts to say whether this other one was proper or not. I think that is the value that can be gotten from the process now because the election has come and gone.
Was the Supreme Court incapacitated, if you will, to that extent that it was unable to give a judgment when fully aware that the elections were just a couple of days away? Did the Supreme Court not see that perhaps that judgment was needed so badly because it was defining a very strong signal that some people who are supporters of the Magnus Abe faction of the APC in River State will feel being cheated in these elections?
Gimba, I think this is one situation where we can, with due respect to the courts, say that one way or the other, the Supreme Court bought into the injustice that was done to the parties. I know that in other realms, in the United States, we have seen contestations play out. These matters will be determined timelessly. But let's not just heap the blame on the Supreme Court. Let me, with every sense of responsibility, say that I developed this impression when the Court of Appeal, after hearing the appeals, delayed for no reason until more than 1 week to give a judgment they had decided they were not going to give, only for them to come back at the end of 2 weeks to say, we do not think that this matter is still necessary because what was decided by the Supreme Court has taken care of it. They did not give a judgment on the matters that were moved before them. They simply stated that they thought that it was no longer necessary. But they held the case for 2 weeks. I think at this stage, we should begin to think seriously of steps that have to be taken to make the judges conscious of the need for them to present the judiciary not as being a party to whatever is happening. I think this is one case where the Supreme Court could have timelessly determined what it was going to determine and give its details at a later stage, knowing that it's a time-bound matter. And I feel that injustice has been done, and the Supreme Court has contributed in doing that injustice, in failing to do so at the time that the decision will be relevant to the process.
Where, in your view, is the genesis of this APC River State feud that we are seeing today? Because this is likely going to define a lot of things and how other states may proceed in future elections. If Magnus Abe, Senator Magnus Abe, was fully in the know that perhaps some illegalities were perpetrated during the primaries in River State and was able to make these complaints to the court. At some point, he did maintain that he did not create the problems for Mr. Cole, who is the other man, the other candidate rather, who emerged through the processes that were open for who becomes governor. Who becomes the candidate for Rivers State. He said that he was not the creator of the problems for Mr. Cole, but the problems were created by those who brought him in. What do you make of that?
Well, Senator Magnus Abe, I think, is absolutely correct. Perhaps just to prove this, you need to recall that there were two matters before the Federal High Court. And some of us in analysis did say much earlier that, look, this is going to give your opponents opportunity to shut you out of the election. And that was exactly what happened. It wasn't just the contestation intra-party. There was also a suit filed by the PDP in Rivers State asking the court to make the same declaration that the candidature of APC is invalid because it's been annulled by a court of competent jurisdiction. And the court agreed. So there were two suits and there were two judgments, all of which were positive to the effect that the candidature of that of the party is invalid. So whether or not Senator Magnus Abe did anything, your opponents as political parties would have taken that step to do exactly what they did and what excluded the party from participation. So it's not just about Senator Magnus Abe's approach to the courts or approaching the courts. It's about the fact that what was done was invalid, and anybody, including your political opponent, will ask the court to take the decision that was taken, and the court will do so because it's consistent with the law.
So as it stands now, who has better jurisdiction? Is it the normal courts, or should Magnus Abe be heading to the tribunal? How is this going to work out?
No, Magnus Abe cannot head to the tribunal because he was not a candidate in the election. APC had no candidate at the end of the day, just the same way we had said it will end up if nothing was done. So they did not participate in the election, and they cannot be seeking anything before the courts on that concerning that election. They were shut out, or they shut themselves out. I must say, party at the center, one way or the other, needs to explain or has some explanation to do on why it allowed itself to be shut out of the election, and why it failed to take steps to weigh in and resolve what was clearly a matter of legality and illegality.
Well, the laws also, the laws, if I may just jump in, at the point where you mentioned the PDP being an interloper in the case, in the case of the APC, but it does have the moral rights to go ahead to do that, to look at the party, and then say that there are illegalities that are taking place in this party, and raise the red flag to INEC, which it did. There was nothing wrong in that.
No, I did not say they were interlopers. I said with the present position of the law, especially the Fourth Amendment, the fourth alteration to the Constitution, parties now have the power to do so. And I warned much earlier, I warned somewhere around October or November. I know other analysts may have done the same. I did say that, look, with the present position, your opponents can go to court validly and get you shut out of the process. The PDP did what they should do. By virtue of the fourth alteration, that's 14th sub, this is clearly within the powers of the party. And so every party needs to obey the law this time, not because the party can choose any candidate it likes, but because their opponents can challenge the process by which they have chosen their candidate. It's no longer an intra-party matter. That is the element that has been introduced by the fourth alteration. It has created a serious room for judicialization of politics, but that is the law as it is now. So the PDP acted properly within the confines of the law, and I'm only saying we did warn that that is going to happen if the party failed to sort itself out within the ambits of the law before the election time. So I'm just saying that was possible. So it was of no consequence whether Senator Abe reacted or did not react, because their opponents would have reacted, and the law has created the room for them to react, which they did in this case.
Let me pick you up on this. Why was there so much chaos for the River State elections, knowing well that the APC was not participating, now knowing well that it's also the biggest challenger to the PDP?
You know, you asked a question that we haven't taken, and that was the question, how did this all begin? I think this election proves a point that whoever is coming into the electoral process must strictly comply with the laws, and that there are consequences for every attempt to act outside the law. There are clear consequences. I am sure that is the full benefit that our political system will gain from this entire matter of River State APC in 2019 elections. Now, powerful people who had exhibited that power in their party and destroyed their party by causing their party to be shut out of the election, took their powers elsewhere and tried to create an opposition that you could practically say did not exist. Because prior to the election, nobody knew of the other party, the party that they adopted and tried to push on through. So the heat wasn't so much about the AAC. The heat was about the powerful persons of APC who tried to use AAC to achieve the goal they had failed to achieve illegally in their own party. There was going to be no contest because clearly PDP was the party running the state and fully here in the state, and the other party that could have challenged it was out of the process. So there was no big deal about it, and there was nothing that could have been done about it. And I think it's the same kind of reasoning that informed the destruction of the APC's chance in the election that was taken to the next party. An attempt was made to see if the same bravado could lead to some result. But I mean, the law is clear on these matters, and even the people can see. Elections are supposed to be about people voting, and people have to vote between candidates that they know. And you can't just put up something and expect the people to follow it, even if you had the social credit of the people being able to listen to you. So I think that's what has played out in that election without APC that gathered that heat.
You know, Prof, even though you say that there was no contest, some will beg to disagree with you and say that the tribunals are still there. But since you say that the APC went to support another party to try to see that he becomes governor and failed in that. Looking ahead, do you think that the tribunals are open to listen to this case, having APC, backing a particular party to try to maybe raise objections in the process?
Well, the tribunals will not see or hear APC. Those who acted are deemed to have subsumed themselves in AAC and try to push the cause of AAC. So APC will have no mention whatsoever in the tribunal. They were not part of the election, so they will have no mention. It's the AAC that they are still going to. That faction that tried to use the AAC will still try whatever it has to do using the AAC. There will be no mention of APC.
Prof, let me get your views on some other matters. This one has to do with the CJN, and you've been watching very closely what's been happening within that path. Now, some believe that this case will fall flat because it was politically motivated in first instance, and also it is not a bona fide case. But what do you make of it?
I've been very worried about the development in the judiciary affecting the CJN, but I have also been very worried about interpretations that my colleagues have given to what was playing out. Now, I believe, looking at the law, that all that transacted properly. It's a different question whether the man who is accusing the CJN has a good case. And it's a different question whether at the end of the day you can convict the CJN. A clear distinction needs to be drawn between suspension as a punishment, as a form of punishment, and suspension for administrative purposes. And the responsibility of the NJC clearly is to deal with misconduct of judges in the course of their work in the adjudicatory function. whether as judges delivering judgment or as administrative judges performing the work of a judge who is in charge of a court or of a court system. It does not extend to matters of the public, of a public officer who failed to comply with the requirements of the Constitution. So we need to draw that distinction. Suspending a person to enable a thorough investigation be done or a trial to be done without losing the integrity of the trial is different from suspending him as a punishment for misconduct. It's only where that suspension is for punishment for a misconduct that it must be carried out by the NJC and recommended by the NJC. But an administrative activity can only be done in this case by the president. The courts do not suspend, the legislature do not suspend. The executive officer who can only handle that administrative suspension is the president. So I think the process, for me, has no problem. Where we have problem is on the substance of the case. And I am watching, and I hope Nigerian lawyers are watching, that we do not get carried away by the irrelevant argument as to whether the process followed was right or wrong. We must prepare to ensure that whoever is behind the allegation, if the allegation is proven to be untrue, is brought to book at the end of this process. Clearly from the matters that have
I'm afraid that that's the much will be taken with you. Unfortunately, we couldn't get those lines very clear on time, but I must thank you, Professor Richard Wokocha, Associate Professor of Public Law, Rivers State University, also the Chairman of the NBA Omoko branch in Rivers State.